हेलो पाटिल सर, स्टार्ट करें क्या?
Yes, sir. Waiting for you.
Good afternoon to all. Greeting to one and all on the behalf of DG Tatkare College. It gives me immense warmth and great pleasure to grace all of your presence in the interest of our entire committee. It gives me tremendous contentment to presenting the welcome speech amongst the most esteemed personalities.
Yes, sir. Waiting for you.
Okay. So it gives me tremendous contentment to presenting
to one and all on the behalf of DG Tatkare College. It gives me immense warmth and great pleasure to grace all of.
Sorry for the disturbance. So I'm starting it again. So, sorry once again. Okay, good afternoon to all. Greeting to one and the one on the behalf of the DGT Tatkare College. It gives me immense warmth and great pleasure to grace all of your presence in the interest of our entire committee. It gives me a tremendous contentment to presenting the welcome speech amongst the most esteemed personalities who have won accolades in their respective fields. I, a system
It is not audible actually.
हेलो, आवाज नहीं आ रहा भानु सर। हेलो, आवाज नहीं आ रहा भानु सर।
Bhanu sir, there is no voice at all. Can you please check?
sorry for the interruption. There was a net error. Okay, so now I would like to introduce Professor Asif Rampurawala sir, the author, researcher, vice principal. Vice Principal from Vidyalankar School of Information Technology, Vadala, has experience of 17 years in teaching, 5 years in as administrative. Sir has published 1 technical paper and is author of 3 books. Second, the Dr. Rajendra Patil sir, the researcher guide, associate professor, Vidyalankar School of Information Technology, Vadala, Mumbai. Sir has experience of 18 years in teaching field, 15 years as an administrative and managerial, 7 years as researcher and industrial, and has published 30 technical papers and is author of 4 books and 1 patent published. Now, I would like to request Vice Principal Rampurawala sir to proceed IPR session. Thank you. And once again, thank you for the interruption. We are very much sorry for it.
I think I will request my friend and colleague, Dr. Rajendra Patil, to start off, and then I will speak after him. Sir?
Yes, yes. Can you please allow me to share the screen?
सर होस्ट बना रहा हूँ, 1 मिनट। क्या है जी, क्या वो लगा जो है सर को देखो कैसे बराबर उठाए, क्लिक करो, देखो यूट्यूब का बंद करना पड़ेगा तब। तो ये सब हाँ सर, वो होस्ट बन नहीं रहा है, राइट क्लिक कराओ 2 ही ऑप्शन आ रहा है उस पे, चैट और पिन।
सर आवाज येत नाही।
Yes, good afternoon all. Can you please check first of all whether my screen is visible and am I audible?
Yes, sir. Audible, visible, both okay.
Yes, yes. Thank you. Okay, so as the theme of this particular webinar was been proposed that some session to be conducted regarding the intellectual property rights. And so as Bhanu sir contacted, and accordingly we suggested that we should come out with this particular theme with an objective to spread awareness about the patent. So after learning from the session, or as an outcome of the session, will be that somewhere you will get some information regarding the IPR, the types of IPR, then the patenting process and all. And this will be synchronized with the session that will be again conducted by Asif Rampurwala sir. So it has been properly classified where certain IPs, यानी जो इंटेलेक्चुअल प्रॉपर्टी राइट्स के जो टाइप्स है लाइक कॉपीराइट ट्रेडमार्क, सो सर विल गिव द टच रिगार्डिंग दैट एंड आई विल बी स्पीकिंग अबाउट पेटेंटिंग एंड ऑल. Okay, so the very first thing when we talk about the patent, so of course the invention, it begins with some idea. So we formulate that idea into some problem, then we transform it into the product, and then possibly you can come out with the patent if it contains the innovation or kind of invention in the process. Okay. So as we use many of the patented products in our day-to-day life, and always we create a big picture that patent is something like those who do something like rocket science koi karta hai, ya something big innovation when someone does, only these people can go for patenting, or only industries should go for patenting. But it is not. Actually, this thing should initiate from the academics. So we should give the thought, we should come out with these innovations through the projects, through our teaching methodologies, some problems what we are trying to solve, and the solutions that we try to provide for the real life problems. So when these things will start practicing and will when it will start happening, so possibly there are bright chances to bring the patents from the academics. Okay. So you can just see in the picture that how what are the things which can be patented. So in our day-to-day life, as the devices what you are holding now in your hand, the mobiles, laptops, the music instruments that you play, the refrigerator, so all this you can just see. So they are the part of IPRs. Okay. So it is just around us. We need to observe them carefully. We need to identify what are the innovative things that exist, and then how it will trigger you to come out, introduce the innovations in the products. Now talking about the patent and all. So first of all, you need to understand these two definitions clearly. That invention is something when some idea strikes, so we formulate it into the product or process. And innovation is something like which has been transformed in the form of product as well as the services. Okay. So like mobile services and all, it is a mode of communication which is now popularly used. And not only now the calls, but now it is almost in the reality. So as we all are connected with the help of technology. Okay. So invention, which is the generation of an idea, and innovation, which introduces the products with the interactive processes. Now let's try to understand ये IP क्या होता है, like IPR, intellectual property rights जब हम बोलते हैं. Okay. So हमेशा दिमाग में एक ही चीज आती है, पेटेंट. हम कभी कभी बोलते हैं पेटेंटेड डायलॉग, ये पेटेंटेड प्रोडक्ट है. Okay. So that patent term has become very patent, isn't it? So IPR is not only patenting, but it covers the following areas we can see, like copyrights, trademarks, patent, industrial design rights, and trade secrets. Copyrights and trademark, as I mentioned, Asif sir will discuss and elaborate that. When we talk about the patent, industrial design rights, and trade secrets, so all these are again the different types of IPs. Okay. So we'll have what are the things that covers under the patents. When we talk about the inventions, तो जब हम inventions की बात करते हैं, discover something, एक नया कुछ product design लेके आना, तो ये सब patent के अंडर आता है. Someone is unmuted. Can you please check?
It is a kind of chemical.
Then comes with the industrial designs. So it covers the external features that immediately stimulates you or appeals you. कि भाई yes, ये design है, जैसे आप देख सकते हो, this mouse is there, isn't it? एक product design है, isn't it? So same way you can have the product design. Take the example of bottles or the shapes which are given to the different products, articles. So many things are there. You just look around you, whatever products you find, every product come out with some design, with some formulations. Okay, shapes are there. Take the furniture, anything you name around you. So that covers the industrial designs and all. Talking about trademarks, so it deals with like logos, the names, words. जैसा आप Raymond लिखा जाता है, okay. So like its font is special, name is there. So all that stuff is covered. Geographical indications, like we say Kolhapuri chappal, Nasik wala grapes, isn't it? So these are the products which are classified and been protected under the geographical indications. The special thing I would like to mention, Ratnagiri hapus, jo bolte hain hum. So that is a geographical indications. Now the same product, if I am growing in my area, या तो नासिक में कोई आम उगता है और उसको मैं रत्नागिरी हापुस बोलूंगा और बेचूंगा, even if it belongs to the same crop, but still it is not been protected under the GI. Okay, आप कितना भी चाहे process करवा लो, but then whatever the taste the Ratnagiri hapus has will not appeal for the Nasik based hapus. Okay. So that's why that specialty, the climatic conditions, the environment and all, so everything matters, which is very important and which classifies that product specially. So ये सब कुछ geographical indications में आता है, like Solapur chaddar बोलते हैं हम, blanket. So like this, the products are famous for. Then your integrated circuits and all, transistors. So again, that is another IP which is covered in India. Copyright, as we are the academicians, we write the research paper, books, notes. So all that is covered. So let's see the patent exactly. It is a license. पहला एक ध्यान में रखो, पेटेंट यानी क्या, ये लाइसेंस दिया जाता है कि ये जो प्रोडक्ट है, एग्जांपल ले लो, ये जो मैंने पेन, एक जमाने में पेन नहीं हुआ करता था, ओके, सो someone discover that there will be the refill in that the ink will be filled, okay, it will contain the ink, then to have a grip, proper grip writing, then the points will be there, see the design, everything. So like this, the product can be used again efficiently. One will be able to write it. So it is a useful thing. So अभी ये कोई copy नहीं करना चाहिए. Okay, ये special design और product इसका कोई special type का pen है. Example I am giving. So you get the license. आप गवर्नमेंट के पास जाओ, गवर्नमेंट को बताओ कि ये मेरी आइडिया है, ये मेरा प्रोडक्ट है, सो आई जस्ट वांट टू प्रोटेक्ट दिस आइडिया. कल अगर मैं किसी को बताता हूँ, इफ समवन लिसन्स टू माय आइडिया एंड ही सेज दैट ठीक है, इफ यू आर नॉट एबल टू डेवलप, आई विल टेक योर आइडिया, आई विल डेवलप एंड गेट द बिजनेस. सो व्हाट विल हैपन आउट ऑफ दिस? द इम्पैक्ट विल बी लाइक ही विल अर्न आउट ऑफ दैट and your idea remains just the idea with you. But somewhere, whatever the other person has done, that is an unethical practice. Unethically means he listened to you or he heard the idea from you. But to have the product protection for such things, for such intellectual ideas, isn't it? So there should be some system at place. So this particular system was being established by the government of India, and that we call it as a intellectual property rights, IP office. Okay, so this patent is nothing but a legal document that grants an exclusive right for you to transform this into the business. Whatever the revenue you are going to generate, or the means whatever the whole and soul rights are required.
Hello.
Okay. So,
ती स्कूलची आता जस्ट मेसेज आयला, स्कूलची एक मीटिंग आता स्टार्ट झाली. पता
yes,
नाही
can you please check?
मतलब लाईव्ह आहे माझ्याला अजून पण होप पुरे देशाची मला वाटते मतलब जी पण काय करतात आहेत ना खूप सारी लोक आहेत. आता फिलहाल ती जाऊ मीटिंग जर खपते 4:30-5 पर्यंत, तर मग मी 3च्या बाद तो वाला क्लास अटेंड करतो. जमल ना?
Yes, the organizers, can you please check with this?
पीर आणि बुध पता नाही, जर आंटीनी मला धाडलेलं लिंक तर मग मी करते अटेंड, तर मग हा तर करता येतो.
Yes, anyone from the organizing, can you please check this?
हो आता हो आता फिलहाल ह्यातलं 60 लोक आहेत माझ्या लवात. नाही दे सायनिंग ठाकलाय. अल्हम्दुलिल्लाह त्याला लाख लाख शुक्र करम है. हा 1 मिनिट मी देते म्हणजे. Hello. Hello.
Madam, you are unmuted and a lot of disturbance is there from your end. Madam. Okay. So talking about the patent, once you get the patent for any product, so you get the ownership of the patent, then you get the exclusive rights for that, you get the protection, means the legal remedy is available for you. Tomorrow if someone violates the patenting, or someone does the infringement of the patent, infringement यानी कोई अगर आपका आइडिया चुरा के कहीं इंप्लीमेंट करता है वही पर्टिकुलर टेरिटरी में, so the law will protect you, the government will protect you. You can sign the contract with some investor in order to promote your product. If you have the idea but you don't have the finance, so some company can make the contract with you and accordingly you can proceed. There are then means whatever the grant and all that you get, so all these facilities you can enjoy after taking the ownership or the patenting. These are some criteria for patent protections, inclusions and exclusions. So what are the advantages that you can just see? The inventions which may be protected, you can just see by patents can be either your process or products. ये समझ लो कि हम क्या patent कर सकते हैं. So in the field of technology, but at the same time, there exists the part of software. Whenever we say the computer or computer applications, so those products are not been patented in India unless and until it involves any of the hardware. Okay, so certain things are there about which you should be aware. For example, a patent may be granted for chemical compound or a process for product producing a specific chemical compound. So always there are experiments which are happening and then some new product is been created or a new chemical structure or a new chemical compound can be created. So such things are allowed for patenting. Simple example, extracting the oil, okay, now from the groundnuts. Now this is a natural process. When you crush the groundnuts, of course the oil is going to be get extracted. But if you are adding some refinement process or something, okay, which is going to make the impact on that oil, or certain oils are there which are precisely used for special type of machineries. Okay, so such type of things can be patented. Then patentable inventions are there, which can be simple products or improvements. So like you can talk about the new design of the machines, or the which can enhance the performance of that machine. So these are the things that comes under the inventions. What cannot be patented? Okay, क्या हम यानी ऐसी क्या चीजें जिसको हम पेटेंट नहीं कर सकते? तो हमेशा ध्यान में रखो, whatever comes with the natural process, so we cannot claim as our patent. Okay, so the discovery of new entities which does not increase the efficiency of existing form of invention. आप कुछ नया आइडिया ढूंढते हो लेकिन वो एग्जिस्टिंग से बेटर फॉर्म में अपीयर नहीं होता है, then it cannot be patented. The rearrangement or duplication of known device. अभी किसी ने माउस बनाया तो लेफ्ट क्लिक इधर, राइट क्लिक अदर साइड, but at the same time you are just changing the functionality. So this cannot be patented. A method of agriculture and horticulture. Okay, because that is the natural thing. Presentation of information cannot be patented. Inventions relating to the atomic energy. Now इसके लिए special reasons है, that means it is banned, isn't it, to do the research on atomic energy? So special permissions are required, and it is happening in a very different manner. Okay, so you cannot claim on that. Then an invention whose use or commercial exploitation could affect the public order or morality. Okay, so these are the things which you need to remember, that does not covers any patenting things. Okay, now what are the conditions and criteria to apply for patent or for patentability? So different countries are having their different laws, and they have their criteria under what circumstances the patenting should be done. Okay, so we can see again, so why one should go for patenting? क्यों हमने पेटेंटिंग के लिए जाना चाहिए? तो सबसे पहले हमको उसका इंपॉर्टेंस जानना है. It is an we get the protection for whatever the invention we make, for those exclusive and use it by its inventor, leverage business, legal recognition to the invention, then which enables its enforcement in the court of law. At the same time, you also may get some funding for further development. हो सकता है कोई आपके आइडियाज में इन्वेस्ट करे, तो जब आप लीगली उसका पेटेंट लेके रखते हो, so it gives the assurance, okay, and also confidence to the investor that person can invest in your ideas, isn't it? So there are of course the different agreements are there, contracts are there, you can have. The very important thing you need to understand, whatever our GDP calculation is there. So the GDP calculation includes the number of patents in your respective countries. Okay, so the economic growth of this GDP matters a lot. So IP plays a very important role. Certain objectives which you need to understand of granting the IPR. तो जब IP ऑफिस यानी जो हमारा इंडियन पेटेंट ऑफिस सिस्टम जो है, whenever they give the patents or grant the patents, so they also promote this to the inventors or to the industries also. So the reason is again to enhance the performance level of institutions. हम बोलते हैं कि अरे ये इंस्टीट्यूट में इतने पेटेंट फाइल हुए, यहाँ से इतने पेटेंट निकले, ये कंपनी पेटेंटेबल प्रोडक्ट्स बनाती है, isn't it? It gives a kind of confidence, as well as it also increases the standard of that institute. It also to give the recognition and financial benefits to the efforts for the creativity. Of course, हमारी जो आइडियाज है खाली वो आइडिया नहीं होना चाहिए, इसको एक कमर्शियल बेनिफिट भी मिलना चाहिए. So again, at the same time, some recognition is also required, so that you get. Then to create the competition among researchers and institutions for quality of research. At the same time, to fasten the technology transfer through licensing and other means. And indirectly, it is benefiting the entire community, society, when the patents are granted. Because when the technology appears in the market, or when some product appears in the market, and when it has been said कि ये patented design है, the product which you are using, isn't it? So it has some weightage. So of course, the standard of that product also increases. पेटेंट रिलेटेड राइट्स एंड एनफोर्समेंट, इसका बेनिफिट एज ए इंडिविजुअल क्या होता है? पेटेंट ओनर हैज द राइट टू असाइन, यानी मुझे अगर पेटेंट मिलता है, सो आई कैन सेल माय लाइसेंस. एट द सेम टाइम आई कैन मेक द कॉन्ट्रैक्ट. जैसा मैंने पहले भी बताया, पेटेंट ओनर कैन एनफोर्स हिज और हर पेटेंट राइट्स ओनली विद इन द टेरिटरी. सपोज इफ आई हैड टेकन द इंडियन पेटेंट और आई एम बीन ग्रांटेड द पेटेंट इन इंडिया, and the same patentable concept, if someone is using in Australia or US, I will not get any legal protection for that. अगर मुझे मालूम है कि ये प्रोडक्ट और भी कुछ कंट्रीज में चल सकता है और अच्छी तरह उधर उसका डिमांड हो सकता है, and to protect, so I should immediately file the patent in Australia, US, UK, जो भी हर एक अलग अलग कंट्रीज में. So what happens with that? So whatever the commercial aspects when they are going to happen there, so of course you will be getting the advantage of that. Either you means the companies will sign the contract with you, or in other way you can sell your license in those respective countries. But whatever is going to happen, you will be benefited out of that. So always see to that कि मैंने खाली इंडियन पेटेंट लेके रखा और रख दिया बस. So it doesn't mean that you are been fully protected. कोई आइडिया इंडिया से सीख ले और यूएस यूके में उसका बिजनेस किया जा रहा है, अच्छा खासा पैसा का अर्न किया जा रहा है, so you will not be benefited for that. So always be careful when you are taking the patent for some product. So it should be again applied for other multiple countries, understanding the product perspective in those regions. Okay. Then a patent owner has the right to exclude all others in the territory. So suppose in case some business is going to happen or someone plans to start that particular product manufacturing or designing, so you will be getting the benefits out of that. And without your permission, it is not going to happen again. So it is covered under the Act 1970. So ये ध्यान में रखो, हम काफी means we have lot of unawareness about this patent system. Patent ये word सभी जानते हैं, लेकिन होता क्या है और ये क्या होना चाहिए, तो we are really not aware about it. We are really living in the world of जुगाड़. Okay, हम काफी सब जगह जुगाड़ कर करके वो सब प्रोडक्ट्स को मॉडिफाई करते, यूज करते, and we are happy, but we don't have that awareness कि इसके फायदे और ये होता क्या है. So it is covered under the Act 1970. अभी आप देख सकते हो कि 70 में कोई एक्ट बनता है और सीधा अमेंडमेंट 2005 में हो रहा है, यानी 35 साल तक इस एरिया में ना नए कभी रूल्स लाना जरूरी समझा या और never the things been modified or amended. You can see the IT Act immediately when it was introduced in 2000. So there was an amendment in 2008. तो कैसा स्पीडीली डेवलपमेंट हुआ. सो अमेंडमेंट कब होता है, जब उसके रिलेटेड केसेस बढ़ने लगती है. हमारे इंडिया में अवेयरनेस ही नहीं था, तो 35 साल लग गए एक अमेंडमेंट के लिए, उसके बाद में तो और कुछ भी नहीं. ओके, सो सी टू दैट when frequent amendments are there, that means many people are aware and taking the advantage or using or practicing. Okay, or somewhere some cases are happening, relevant things. In India, many products are being duplicated. Neither the original the owner is bothering about it, or never he will go for those legal remedies and all. So that way the things are happening. But when that awareness will be spread, so many things can be controlled. Because when duplicate product appears in the market, so it affects the customer also, and it affects the original brand as well as the economy, isn't it? So the act is applicable for the entire country because it is an Indian Patent Act, and it shall come into the force on the date as prescribed. Okay. So this particular department comes under the Ministry of Commerce and Industry. Okay. जो intellectual property rights वाला department है. The invention relates to a process or product or both. It involves an inventive step. The invention, it also deals with the machine. So you can see. अभी होता क्या है जब ये हमको पेटेंट दिया जाता है गवर्नमेंट की तरफ से. So this particular patent is having some validity. Of course, जब हमें लाइसेंस या पासपोर्ट दिया जाता है, so there is some validity, 10 years, 15 years, that way, isn't it? So in the similar way, this patent period is for 20 years. And after 20 years, again, you have to complete that process. If really that time, 20 साल बाद भी वो product का पूरा design and everything is up to the mark, then it can be patented or renewed. Otherwise, it can also be rejected. Okay. And suppose if someone challenge your patent within 20 years span also, and if it feels that the originality does not exist with that particular inventor, ये तो कुछ और ही बात है, so then it can be withdrawn also. Okay, ये भी ध्यान में रखो. Now, is the patent granted in one country and enforceable in other? Just now I told you that for every country you need to take the patent rights. So the different territorial regions are there, like India के लिए India में मिलेगा आपको. So whatever patent is granted, so it is for the entire country. ऐसा नहीं कि खाली मैंने मुंबई में लिया तो महाराष्ट्र तक limited रहेगा. No. So in the entire country, you have the right and you become the owner of that patent. Okay. See, again, there is a refusal of the patent in one country does not mean that it will be accepted. अभी software related patent हमारी इंडिया में नहीं होते, generally reject किया जाता है. It covers or it comes under the copyright. But the same can be granted in US, Germany, Australia. Okay. हर एक country का अपना अपना एक means as they have their own classifications, product classifications, the IP classifications, and accordingly then they allow to be protected under the respective IPs. Okay. Rideshwar Bhatti, ये जो बंदा है ये सबसे youngest patent holder है हमारी इंडिया का. So at the age of 9, he introduced this 6-player chess game. आप देख सकते हो पिक्चर में. So this person that 6 people can play chess at a time. और एक खुद उसने डिजाइन किया हुआ चेस गेम है. Okay, chess related many patents are there. One chess is there where the blind people can play the chess. So they will have their braille lip and using that keyboard they make the moves and automatically the board पे वो movement होता है. So like this, the product related patents are possible. So this is the one example just to motivate you. So copyright, you can see the author's lifetime plus 50 to 70 years. So this is the duration for copyright. For trademark, it is 5 years, patent 20 years, industrial design from 10 to 20 years, and trade secrets, it is indefinite. Okay. Example है Coca-Cola. आज तक उन्होंने कुछ भी पेटेंट नहीं किया है, but whatever their trade secret is there, only that they had protected. Because 20 साल के बाद वो public domain में आ जाता है. And Coca-Cola was quite confident till date. यानी कल अगर किसी ने वो चुरा भी लिया, okay, and if someone makes, so Coca-Cola अगर कोई वो taste flavor देना भी चाहेगा, so Coca-Cola cannot again claim for that. because they are not protected under that. So what are the legal remedies that those are available? तो remedies यानी क्या, आपको protection मिलता है. किसी ने infringement कर लिया, किसी ने copy किया तो क्या हो सकता है और उसकी process क्या होती है. Okay, so remedies for your IPR infringement are which are common to all IPs. So if it is actually your whatever your actual damage, abhi suppose I had designed some this pen drive, okay. Now the beauty is like some design, protected design is there and something, the product is there. And without my permission and all, someone copies the idea and starts manufacturing. Okay, now since this belongs to the Sony company and they have their own technology, very useful technology, उसमें मैं SONI Sony कर देता हूँ. ये SONY, this is the original name. So I am violating many things, isn't it? The brand I am affecting, the product I am infringing. So whatever the actual damage royalty, आपको जो चाहिए उतना amount आप claim कर सकते हो. Even that calculation has been done by the experts after setting up the committee and all. और जो profit किसी सामने वाले ने कमाया होगा, the market revenue what they had earned, then the legal cost which you are spending there, attorney fees and all, so everything you can claim. Okay. And this is applicable in the similar manner for all the IPs. So, like monetary relief is there, equitable relief is there, cost and attorneys. So you can all see here. This is the example which you might be aware again, that Apple sued HTC or iPhone patents. So HTC ने थोड़ा उनका जो pattern design, वो जो सब structure था उसका, so they tried to copy it. Okay, so that time the Steve Jobs, he made the statement that we think competition is healthy, but competitors should create their own original technology, not steal ours. Okay, because of course the Americans, they respect the innovations and one should respect again to be idea hota hai. Either you go to the company जिसका patent holder है, उससे बात करो, उससे agreement करवा लो और आप एक आपका brand बनाने के लिए ऐसी भी कुछ चीजें होती, इस तरह के भी business होते हैं. So you can do that, but unethically it should not be practiced. This is the another popular case. आपने सुना होगा जो spark ignition था, DTSI. Okay. So Bajaj XCD with this TVS. So ये इनका जो ये जो टेक्नोलॉजी इग्निशन स्पार्क इग्निशन का जो टेक्नोलॉजी इंट्रोड्यूस किया गया था. ओके, सो दिस वाज द फेमस केस. So one was related, so this particular case was having two aspects. One was related to the patent infringement and the other was to the speedy disposal of intellectual property right cases. Okay, so the case was like between the digital twin spark ignition and TVS motor. They were the defendants. So the DTSY was the intellectual property of Bajaj. So इन्होंने case file किया था. Plaintiff, यानी, okay. So they had applied for patent application for the technology in 2002 and it was granted in 2005. Okay, so this was the one case. दूसरा ये भी सुना होगा जैसा बासमती. This basically this is the variety popularly appearing on the border of India Pakistan. So Punjab Prant वगैरह जो होता है, so there you can just see. So we have those categories like Sapidun, Haryana, Kasturi, Basmati 198. So all those the listed one. Whereas from Pakistan we have the other this varieties. So इसके basis पे एक company था Rice Tech. Okay, so they claim, they put the 20 claims about their product, from which few ones are like semi-dwarf in stature, substantially photoperiod insensitive, high yielding. Okay, then some characteristics which are similar as well as they are superior than the basmati rice, the original basmati rice. So that invention provides method for breeding those novel lines. Okay, the starch index of that rice can predict the grains cooking and starch properties. तो ये सब कुछ उन्होंने क्लेम करके उनको एडवांटेज जो मिला एक कंपनी को. So they were not, means Rice Tech able to not only call its aromatic rice basmati within the US, but also label it as basmati for its exports. Okay, then they got the benefit in their trade and all. So this way, this particular Rice Tech वाला जो केस है ये डिस्कस हुआ. तो इस तरह का जब बायो पायरेसी बोला जाता है इसको, so there are remedies which are available, like the national policies for this sustainable use of biological resources are there. So the national laws, they protect and they cover these conventions on biological diversities. तो काफी जो अलग अलग तुमको varieties मिलेगी जो cotton seeds के बारे में भी होती है. So like this, the biopiracy, when this is now happening, so it can be protected. So these things are now being protected in India also. About the turmeric, you might have seen, जैसा एक US ने पेटेंट करके रखा था 1995 में. It was granted to them, and they were calling it as a medicine used for healing purpose. Okay. तो ऐसा वो क्लेम करके उसमें उन्होंने US पेटेंट करवा लिया था. And again, they were the Indians only who took the US patent. So when Dr. Raghunath Mashelkar sir, when he was chairman at IC, this our national labs and all, okay. So during that during his tenure, so when he went through this particular publication and all, so he filed, he defended, not defended actually, he was a plaintiff, and then he filed in US patent office that this is the originality of India. Okay, and he provided a lot of evidences, and then later it was been understood by the US patent office that this is the original product of India. And whatever the patent which was granted, it was been withdrawn. Okay, so this was the case. You can see about this. So when sir was at CSIR, okay, Council of Scientific and Industrial Research. So during his tenure, this particular case became very popular, and how it belongs to the Indian territory. Okay. So all this happened again since we were not having the awareness about it. यानी product हमारा लेके गए वो और उधर अपना claim कर रहे थे. So he is the one, everyone as we knew him. As you had seen, जैसा बीकानेरी भुजिया, कोल्हापुरी चप्पल, सोलापुरी चद्दर, okay. Then your Ratnagiri apus. So all these are the geographical indications. Now इसके लिए भी ये file करने के लिए government has the process. So when you register it as a geographical indications, so it has to be through geographical indications of goods, and there we are getting the protection under the Act 1997. So it prevents unauthorized use of registered geographical indication and promotes the economic prosperity of the producers of the goods. Okay. कभी कभी कोई भी रत्नागिरी आपूस बोल के उसको बेच देता है. People blindly trust, and as a result, when the taste is not good, it may affect the original brand. So one should be aware about their geographical indications. कि कोई अगर अपना रत्नागिरी हापूस करके still these things are happening. Means in Mumbai also everyone calls Ratnagiri apus. खरीदने वाला भी expert नहीं होता है, and then due to lack of awareness, then sometimes if the product is not good, so it spoils the name of that particular product. Here you can see the global trend as per the data available. So from 3 to 17. So what were the applications and how that growth rate was there in the number of applications which are filing. We are still one of the developing country. Okay, we are not developed already. So still we are struggling to come out with our presence in the world of this IPs and all. The IPR laws which are protecting, you can see it was introduced, then the amendment was there 2005. Then the Trademark Act was introduced in 99. See, the copyright in 57, the Design Acts in 2000, GI Registration and Act in 1999, the Semiconductor Act in 2000. Okay, so like this, all these IPs were introduced step by step. As I had discussed, that everything this comes under the Ministry of Commerce and Industry, as well as the GI indications and all, they comes under the Ministry of Environment and Forest. Okay, also under the Department of Agriculture and Corporations. These are the offices one should know. You can file the applications anywhere. Like there are offices in patent in Mumbai, Kolkata, Delhi, and Chennai. You can file anything at any office, but then final approvals, जैसा भी आप डिजाइन के लिए स्पेशल ऑफिस है कोलकाता, ओके, ट्रेडमार्क रजिस्ट्री जो होती है मुंबई हेड ऑफिस, दिल्ली में, कोलकाता, चेन्नई, GI indications, then there is a Chennai is granting, copyright Delhi, okay. So पेटेंट रिलेटेड जो है ये चारों जगह काम चलता है हमारा, बट फाइनली द थिंग्स आर कमिंग फ्रॉम कोलकाता ओनली. So you should be aware about this, also the process, okay. Will not go into this. Let's try to understand this patent system. So again, as their objectives, we had learned that to encourage the invention, to secure the patent works in India, benefits to be available to public at affordable price and not granted merely to enjoy the right of importation. Now, recently you might have seen the COVID vaccine and all. Globally, it was been decided nowhere this will come under any IPs. Otherwise, it would have been the monopoly for anyone, and it would have come out with any cost. People were ready to buy the vaccines again. So such things should not happen. Okay, there should not be the monopoly for the product. So again, that care is also taken by the government. Then to ensure the transfer and dissemination of technology. Okay. Now, India is one of the founder member for of this World Trade Organization, WTO and TRIPS agreement. Okay. So ये कहीं ना कहीं कुछ cyber, when you have the IP and papers, in that somewhere you might come across through this. So whenever you want to conduct the business, अगर patentable product का आपको business करवाना है, so a group of countries are there where there is an agreement between this, that certain products, whatever we have. So just to make the trades, I mean, bring the flexibility in the trades. So this TRIP agreement is been formed, and under these agreements, it allows the different companies to do their business with certain compliances again. At the same time, they are also been protected with the IPs and the legal remedies. Okay. Will now, just for your knowledge, nowadays you might be hearing a lot about the startups and all, like काफी startups आ रहे और क्या होना चाहिए. So any of the company, when the startup is there, of course it is for something new, innovative idea. And of course, there is a role of some technology and all. So when these companies are initiating their business and all, so for these companies, they get the 80% fee concession. But see to that, this यानी ऐसा नहीं होना चाहिए कि startup form कर लिया, सब business चालू कर दिया, and then you are now applying. So simultaneously, you have to apply when you have the new product ID and all. So these are the means the commercial fees and all. Of course, company form किया जाता है, उसका trademark design, so ये आता ही है, as well as the patent fees are there. Okay, so these are the benefits. The process is like e-filing, यानी आप online filing कर सकते हो या actual office जाके भी file कर सकते हो. Nowadays, most of the e-filing are happening. Examination is there, product examination. So there are patent examiners in the patent office. They are experts of that particular area. Suppose something related to IT, then IT experts are there. Something related to electronics are there. Biomedical, pharmaceutical, all field people are there. They are playing the role of these examiners. Then there is a disposal, then pendency is there. So certain products which are just been delayed for several years. At the same time, there is a domestic filings, okay, local level पे जो किया जाता है. So this is the status. And now as a result, I will show you the process, how it happens. So after filing and the publication is there. जैसे आपका application file किया जाता है, उसके लिए form 1 fill up किया जाता है. Okay. Before that, again, you can also go for pre-application. एक process होता है. Application के पहले ही line में आप खड़े हो जाओ. That is a pre-application. Line में यानी not physically. You just claim that I am going to file the application under this particular area. So still आपको उसका benefit मिलता है. Then there is a publication. Then the request for examination. Examination यानी जैसा मैंने अभी बताया, the experts are verifying your concepts. They check the innovations, the originality of that innovation. Then there is a first report examination. Means first examination report is generated. अगर उनको कुछ objection रहा, then they communicate the inventors. Otherwise, they have the means there are chances that directly the patent can be granted. Okay. Earlier it used to take around 4 to 5 years, but now it has been reduced now. Up to means that process is now coming under, can be completed within 1 to 2 years span, just because of the online and all other things. Okay. Once you are, so these are the cost again which is incurred. So अभी कुछ इसमें जाने का जरूरत नहीं है. How that application is actually, this is the one of the application when you draft your patent claims and all. So आपकी जो novelty है क्या है, उसकी diagram क्या है, उसके specifications क्या है, all that you have to give the description like research paper only, but in a very technical approach. So there are patent attorneys, the drafting peoples are there who give the guidance and who conduct the entire process. Of course, there is an agreement between the inventor and with that IP attorney also. Okay. So this is the flowchart for the process. Here I'm just putting up some roles and responsibility of university or colleges for IPR. So here you can see that it should be, first of all, introduced in the syllabus so that people will be having the awareness. There should be IP officer at institute level. Then you should conduct some seminar, conferences, जैसा अभी आज आपके college में conduct करवाया. So like this, you can just claim university protection of and transfer of commercialization rights. Then you can have the collaborative engagement with some private sectors. Okay. And at the same time, you can come out with some new career opportunities for your existing staff, students, and all. So within the institutions, benefits in the following way: ownership issues in the past, rights under the Patent Act, and research councils and charities. And here the IPR, when you have the industry collaborations. So as an IPR in academics, so you can just get these benefits. These are the opportunities for university and colleges. You can come out with the entrepreneurship, startup schools and all. So this engagement or this model may be probably in under NEP. This can be the part of practice. Okay. You can see as Thorsten Barth. So he has proposed this model. Okay. This is about the fees and all. See, form 1 has to be filled for application. अगर आप प्रोडक्ट का फुलफिलमेंट नहीं कर सकते हो, आप प्रोटोटाइप नहीं बना सकते हो, तो आप उसके लिए एक्सटेंशन और ले सकते हो 4 months. So 300 per month के हिसाब से फीस आपको ऐड किया जाता है 1200 rupees. Then after that you can request for publication. Publication means उनके legally official website पे आ जाता है and this is the claim you are putting up. So it is in the publication mode. Examination के लिए form 18 fill up किया जाता है. So that is the next process. And as an individual, then you have to bear the cost as well as the legal that varies again. Okay. Then renewal fees are there. एक बार patent grant हो गया आपको, so after 3rd year to 6th year you have to pay 500, 7 to 10 year 1500, 11 to 15 years 3000 every year, and 16 to 20th year 5000. Okay, so these are the protection fees. And the citations, whatever the PPT has been shared with you all. So we'll take the questions if you have. That's all from my end. Yes, the organizers, if there are some questions. What question has been asked by Dr. Shilpi Jha, that patent has to be taken in all the countries. Yes, already I had mentioned earlier also. I guess you might be clear with that. Wherever you feel the trade is possible or you find a better perspective for that product, so you should be, means it is always good to file the patent in those respective countries. Okay. So thank you. Yes, anyone there from organizers?
Sir, if you make me the host, I will start.
Yes. Okay.
Thank you. Good evening, everyone. Let me just share my screen. Just like to confirm if you have been able to.
Hello.
Good evening, sir. Yes, ma'am. So I would like to continue from where Dr. Rajendra Patil left in terms of, we talked about patents and geotagging and geographical indicators which are there. Today, I would like to talk a little bit more about, two topics mainly. One is copyrights and the other is trademark. Now, when we look at copyrights, many of times people have a little bit of a misunderstanding, okay, and about copyrights. And I will try to clarify those misunderstandings and try to tell you how we can use copyrights to our advantage. If a man is keeping an idea to himself and that idea is taken by stealth or trickery, I say it is stealing. But once a man has revealed his idea to others, it's no longer his alone. it belongs to the world. This is a very important quote by Linda Sue Park. And this I would like to, elaborate a bit more on. When we do academic research, the idea of academic research is to increase the body of knowledge we call as, sciences. So when we do any kind of research and we do a publication of that research, or when we do any kind of publication, what we have done is given that knowledge to the world. However, do we still have ownership over that idea? In this respect, intellectual property rights has been developed, and the meanings of these intellectual property rights have been, discussed, deliberated, and now standardized almost across the world. And here we will see, how patents and copyrights and patents and trademarks are slightly different. So before I take any discussion forward in terms of copyright, because all of us are from academics, I think the most suitable topic to discuss first would be about plagiarism versus copyright. Many times plagiarism and copyright are misunderstood. When a student is caught plagiarizing, or a research scholar is found to have plagiarized some research material, or a faculty or a researcher is found to have used somebody else's piece of work within their document without proper paraphrasing it, without converting it into their own words, without having done the correct citations and references and everything, it becomes an issue of plagiarism. However, no matter how serious that matter of plagiarism is, it is always an ethical issue, not a legal issue. Plagiarism is something which might be a reason why somebody is thrown out of school or college, or is fired from a job, because you have broken the code of ethics. However, you might not be liable in court. You might not, it is not considered as a criminal offense, because plagiarism or anti-plagiarism is not a law in many countries, in almost all countries. However, copyright is a matter of law. It's not something which you can do very lightly. Copyright is a legal issue. Okay, so the Copyright Act in India came into being in 1957, and then the rules were formulated again and amended in 1958. From that time till today, there have been many amendments in that act. Also, somewhere in the 90s, India became a signatory to something known as the Berne Conventions and the Universal Copyrights Conventions. As a result, now our copyright law is based on an internationally set standard of what is to be understood as copyright in various fields. The most important aspect of what is copyright and how it is implemented is to understand that copyright is only comes into effect for something which has been realized or in a physical form. For example, if you have an idea in your head, you cannot copyright it. If you have spoken about that idea to your friend, it does not mean you have a copyright about it. If you talk about that idea on a stage or in a lecture classroom, you do not have a copyright on it. However, if you can record it either on a piece of paper or in an electronic format, then that same idea, that same concept, or that same lecture becomes your copyright. So for example, if this webinar would not have been a webinar and would have been a seminar where I would have been possible, it would have been possible for us to, interact face to face. Wouldn't it be lovely, after so many weeks and months of having to talk to computer screens, to actually see people and discuss these kind of topics. It's a I don't know, ye dream kab pura hoga, when we will be able to see each other physically, face to face and interact. But if I would be doing this lecture or this talk face to face, whatever I would be saying is anybody can use it. No problem. I cannot claim a copyright on it. But because today's session is being streamed live at the same time being recorded, automatically whatever we say today gets copyright protection. Now, this is a very important aspect. If you want to copyright your lecture, you can do that. If you have a very interesting lecture, you can copyright your lecture. The only criteria is either you will have to transcript it, that means you will have to write it down verbatim, or maybe do a recording, audio recording or a video recording or an audio video recording, whatever is possible. And then you can, the content which you create will become your copyright. I would like to take a small case studies over here. This is a case study of University of Oxford versus Rameshwari Photocopy Services and Delhi University. So in the Delhi University, within the university campus, there is a photocopying service provided for students by the university. Now, there was a court case against that photocopying studio, the operator of that photocopying service, and the Delhi University themselves by Oxford Press. The reason for this was that many of the books of Oxford Press, Oxford University Press, were being photocopied, and those chapters of those books were compiled into a form of a notes for certain subjects and being sold to students. University of Oxford, or the Oxford University Press rather, went to court claiming damages because all textbooks have copyright protection. All books which are published, legal publications, have copyright protection. And in India, we have a Copyright Act which guarantees that protection. However, the law is not that simple. The law states that one, the material which is copyright protected should not be misused. Fair use of published material is allowed. Now, what constitutes fair usage is open for interpretation. And in this case, the Delhi High Court ruled that since the photocopying service was provided for educational purposes, and those books which were published by Oxford Press and they were claiming damages were very, very expensive, and therefore the students would not buy those books even if the photocopying service was not available. If the photocopying service was not available, nobody will buy the books because वो बहुत महंगी है. So therefore, even if those photocopying service was not there, there would be no loss of revenue. So the loss of that notional revenue which Oxford Press is claiming is not substantiated in fact, but is just a notional loss. And therefore, since the usage of this material has been done only for educational purposes and not for commercial purposes, and at the same time there is no concrete evidence to prove that there is been a loss of revenue to the publication house, therefore this photocopying of certain chapters from books for educational purposes was granted or deemed as fair usage by the Delhi High Court. And this is one of the landmark judgments in India regarding copyright law when it comes to printed textbooks. Another case is a case of a novel by R.G. Anand, which was later claimed to have been adapted into a movie. I've put up the photograph of the movie banner, Ashok Kumar, if you know him. So this movie talks about a South Indian boy coming to live in Delhi as a neighbor or as a paying guest near a North Indian girl's house, and their love story between them and their family, issues regarding interlanguage, interstate marriages and stuff like that. So this is a very old movie. A very similar story was written in a book which was claimed that R.G. Anand discussed with the director of this movie before this movie was made. And therefore he claimed damages and wanted to file an injunction against this against the producers and wanted to stop the release of the movie. However, again the High Court observed in this case that the story which was written in the book had the female as a South Indian and the boy as the North Indian, and the detailed situations in the book do not directly match the movie, and therefore it is hard to prove that it is an exact violation of the copy of this book or the copyright of this book, and hence this was considered to be not eligible for copyright protection, or it was not deemed to be a copyright violation. These are some interesting case studies which determine the fair usage policy provided by the Copyright Act. So whenever we talk about a copyright, please understand, copyright करने के लिए कोई registration process करने की बहुत बड़ी जरूरत नहीं है. When your original idea or a piece of work, whether it is a literary piece of work or a photograph, a video, an audio piece, a movie, or any kind of format, if it is coming into existence on paper or in print or in any form of electronic media, you have a copyright to it by default. Who has the copyright? The person who creates it or the company who is paying for its creation. Thereby, you even have a copyright even if you don't go and register. There is a copyright registration process. You can register copyrights. But even if you do not register it, अगर आपने एक YouTube वीडियो बनाया है कुछ ओरिजिनल आइडिया लेके और वो आप YouTube पे पब्लिश करते हो, आपके पास कॉपीराइट है उसका. अगर आप वो वीडियो अपनी खुद की पर्सनल वेबसाइट पे डालते हो तो भी आपके पास उसका कॉपीराइट। So the purpose and character of the use is very important when it comes to determining fair use. अब अगर मैंने एक लेक्चर बना के ऑनलाइन रख दिया तो क्या वो लेक्चर कोई कॉपी नहीं कर सकता? कर सकता है। वो क्या नहीं कर सकता है कि वो मेरा लेक्चर उठा के खुद अपने क्लास में यूज कर ले, ओके, फॉर कमर्शियल पर्पस। फॉर एग्जाम्पल, अगर कोई एक ऐप बनाता है जिसमें सपोज दे वांट टू टॉक अबाउट कॉपीराइट्स, डिफरेंट टॉपिक्स दे वांट टू टॉक अबाउट, एंड समझो किसी को पेटेंट्स के ऊपर बात करनी है और उस पर टॉपिक है पेटेंट्स, और वो अभी जो हमने पाटिल सर का लेक्चर सुना, अगर उसको रिकॉर्ड करके वो वहां पे उस वीडियो उस ऐप में डाल दे, ये रिकॉर्डेड वीडियो यूट्यूब पे अवेलेबल, उसने वहां से डाउनलोड किया और डाल दे, तो वो कॉपीराइट वायोलेशन होगा, because he or she is doing commercialization of the lecture which was given to free of cost to the public. So it will not be considered as fair use. So if that video is being used as, you know, कोई अगर उसके फेसबुक मीडिया पे, अगर आज का लेक्चर कोई फेसबुक पे शेयर कर देता है, सपोज आप अपना फेसबुक पे ये वीडियो शेयर कर देते हो, then it is not copyright violation, because ये सोशल मीडिया में शेयर करना फ्रीली अलाउड। जब वो वीडियो से आप पैसा कमाओगे तो वो अनफेयर यूसेज हो जाएगा। Also, it is very important to know the amount and the sustainability of the portion of the work which is used. So for example, if it's a book and if you photocopy the entire book cover to cover and sell it, या आप पूरी की पूरी बुक को कॉपी कर देते हो और आप ऊपर अपना नाम, किसी ऑथर का नाम हटा के अपना नाम रख के पब्लिश कर देते हो, तो देन यू विल बी हेल्ड लायबल। बट अगर आप 500 पेज की बुक में से 50 पेज का फोटो कॉपी करके अपने बच्चों में बांटते हो, फॉर इफ यू गिव इट टू योर स्टूडेंट्स फॉर एजुकेशनल पर्पस, एंड यू ओनली चार्ज द स्टूडेंट फॉर द फोटो कॉपिंग कॉस्ट, फोटोकॉपी का जो भी कॉस्ट होगा वो बच्चे भरेंगे, then it is not considered as a copyright violation. So the effect of the use of the potential market of the copyrighted work is also to be understood when it comes to determining fair usage. So is copying or making copies of some material violating or preventing the owner or the author of that material from making revenue is also to be judged when you want to determine fair usage. So when it comes to online teaching, okay, you have to understand that when you create a recorded lecture or a session, who is the owner of that copyright? Is the teacher the owner of that copyright, or the institution for which you work, are they the owners? So by law, the educational institution who is paying you for delivering the lecture to their students technically owns the copyright, unless you have an explicitly signed agreement with them. So if an institution wants to commercialize these lectures which you are giving for your own or company, for your own institution, into some kind of a revenue model, there will have to be some they will have to come up with a policy which will be allowing you to either share revenue or to give up your right to the content. Now, YouTube videos, as I already said, are by default, they have certain kinds of copywriting licenses. When you publish a YouTube video, you can actually choose which license you want to belong to. So when you are using a YouTube video, for example, कभी-कभी हम लोग use करते हैं in our lectures, we use YouTube videos of different people. always remember, you can share that video or use that video in your lecture as long as you do not upload it yourself onto YouTube. So बहुत बार कुछ लोग क्या करते हैं, वीडियो को डाउनलोड करते हैं और फिर अपने चैनल पे वो वीडियो अपलोड कर देते हैं. वो गलत है, वो कॉपीराइट वायलेशन है. It does not matter if the video is a short clip, 10 seconds, 30 seconds, you still can't use it. So if you want to legally use some, let's say a picture, a photograph, or audio piece, or a small music piece, or a video of somebody from the internet, you should explicitly ask for permission, written permission from them before you use it for any purpose. That is the right thing to do. YouTube, in fact, has built an entire copyright management suite, which gives right holders control over their copyrighted material on YouTube. So if you are somebody who's a content creator and who uploads content onto YouTube regularly, you should use this copyright management suite to protect your content from being, copyright violated. When you upload videos on social media, no matter whether it's on WhatsApp, on Facebook, on LinkedIn, or any other platform, TikTok, or वो जो भी आजकल अलग-अलग चल रहे हैं apps, they have to read the terms and conditions of that platform very carefully when they upload. कि वो content पे क्या वो अपना copyright grant कर रहे हैं क्या किसी और को? Many of the times we don't read the terms and conditions and we accept blindly. And this can be a downfall. Because कौन पढ़ेगा वो terms and conditions दो पेज 3 पेज का लंबा, वो next बोला accept करने बोला था, accept किया, yes किया, okay, we go ahead. Don't do that. When if you are creating your own original content, you should worry about the agreements which you sign. अगर मैं आपको कोई ब्लैंक पेपर पे साइन करने को बोल दूंगा, क्या आप साइन कर दोगे? नहीं. आप देखोगे कि क्या लिखा है, क्या नहीं लिखा है, ऐसे आप साइन नहीं करोगे. क्यों? क्योंकि आपको मालूम है कि उसका क्या मिसयूज हो सकता है. उसी तरह when you accept the terms of a licensing agreement, what you are doing by clicking that yes is basically as good as signing that document. So be very, very careful. If you want to register copyright for some app which you are wanting to build, many people have very good ideas nowadays, when in academics also, when many people come up with their own apps, you should make sure, okay, that computer program cannot be patented, but the work which you do and get published as a computer program can be copyright protected. Okay, in India, programs cannot be patented. Program matlab software programs. But software programs can come under copyright protection. So we can register for copyright for our code so that it helps people who have created, softwares or apps for mobiles or something to be protected. So the questions you may have asked, can you copyright your lecture? Can you copyright your lecture slides or lecture notes? The answer is yes, they can be copyright protected. Do students own the copyright for their notes? Technically, yes. Can you prevent students from sharing their notes with others? The answer is no. However, there is a case study which is very important, which I will do in a minute. Remember, knowledge is not copyrightable, but knowledge expression in tangible form is copyrightable. Expression in tangible form is once you have it in written format or a recorded format. So this is a case study where University of California, UC Berkeley, tried to prevent students from profiting from notes. So there were these students who every year notes banate the apne class ke, and they used to sell it to their juniors. So they gave a specific, note to students that instructors copyrights, that whenever individual instructors will retain copyrights to the lectures and their class presentation, class material they create, and the related material pursuant with the US copyright law. Yes, agreement उन्होंने ऐसा दिया था. It forbids students from reproducing, sharing, or distributing notes for commercial purposes or compensation, or to share notes with students currently not enrolled in the same class. However, legally this cannot hold. Okay, so there was this case where Dr. Merton, a professor, he made all his students purchase a $90 CD, which included student study guides, practice exam questions, and other audiovisual material which he had created. Class Notes was in the business of collecting material and class notes from students. And the lawsuit, Class Notes is an online app हुआ करता था, जो बच्चों से material जमा करके it used to sell other students. The lawsuit alleged that they were infringing Dr. Moulton's copyright because वो $90 की CD बेचते थे अपने students को. अब वो सारी चीजें क्लास नोट्स पे सस्ते में अवेलेबल थी. बच्चों ने किसी बच्चों ने उनको दे दी, अपलोड कर दी क्लास नोट्स पे. अब वो क्लास नोट्स पे सस्ते में अवेलेबल हो गई. So there was this violation, and this matter went to court. यहाँ पे because Dr. Moulton had created a CD of all his content and it was commercially being sold, therefore in this case Dr. Moulton won the case, and Class Notes, the website which was selling that material to other students, was stopped, was not allowed to sell that anymore. So one of the questions which always gets asked is it necessary to register a work to claim copyright? Technically, no. There is no formality required to claim copyright. To acquire the copyright, the moment the material comes into existence in a tangible form, that means either a written format or a printed format or a electronic format, no problem. Once it comes into that format, it is automatically comes in your copyright. However, registering copyright is always a good idea. If you want to, make sure that nobody infringes upon it. नहीं किया तो भी problem नहीं है, कर दिया तो better. So do you need a lawyer or an agent to do this? No, you don't. You can file the copyright work yourself. Okay, and either post it, or nowadays everything is available online. So there is something called as copyright.gov.in India mein. You can go to their website and follow these steps. So there is a registration form. It's called form number 14 of the Copyright Office, which you have to fill in and submit along with your material which you want to copyright. And then wait for 30 days for anybody to claim objection on that material. If there is some objection, you have 45 days to answer and make sure that those objections are removed. And once that is done, you will get your copyright in a matter of 2 to 3 months, depending कि आपके material पे कोई objection आए या नहीं आए या कितने objections आए. This is a very simple, straightforward process and does not cost too much of money, depending on what we are doing. So यहाँ तक हुआ copyrights के बारे में. Now, let me take you to trademarks. Now, trademark is a different piece of thing. आप लोगों ने बहुत बार देखा होगा TM लिखा हुआ, बहुत सारी चीजों पे TM लिखा हुआ था. जो सिंबल होता है TM, वो क्या इंडिकेट करता है? It is generally a short form for trademark. So what is a trademark? Trademark is a word, phrase, name, or symbol that is identified with a company. So this TM, जो लिखते हैं हम लोग, superfix, claims that the company owns the trademark. However, it is not does not grant any legal rights to the company unless you register that trademark, and then you will write an R enclosed in a circle. So when you write this R enclosed in a circle, okay, this is the symbol. That means you are a registered trademark. Just writing something. Okay, for example, मैं अपना नाम का कंपनी बना दूं. आसिफ इंक. I can automatically write TM. TM लिखने में आप भी लिख सकते हो अपने किसी भी प्रोडक्ट या किसी भी चीज के ऊपर आप अपने नाम, तो अगर आप कुछ चीज को नाम देते हो आप TM लिख सकते हो, कोई प्रॉब्लम नहीं. TM लिखना कोई प्रॉब्लम नहीं है. What you cannot write is a registered R symbol. R के लिए you will have to register. So registered trademark is a word, phrase, name or symbol which has been registered with the Controller General of Patents, Design and Trademarks, which comes under the Ministry of Industry and Commerce of the Government of India. So TM और R में फर्क हमेशा समझ लीजिएगा. तो क्या क्या चीजें ट्रेडमार्क की जा सकती हैं? बहुत सारी चीजें ट्रेडमार्क की जा सकती हैं. जैसे कोई नाम हो गया, कोई टैगलाइन हो गई. ओके, अ वेरी सिंपल एग्जांपल इज नाइकी का swoosh सिंबल है. Nike has this symbol which is like a, this is called the Nike's swoosh symbol. Sorry for my bad design. That swoosh symbol is also trademark protected for Nike. कंपनीज के सारे प्रोडक्ट्स के नाम होते हैं. ओके, जैसे अगर आप देखेंगे अलग अलग कंपनी ब्रांड के मारी के बिस्किट्स मिलते हैं, बट अगर आप देखोगे तो हर एक मारी का नाम थोड़ा सा अलग होता है, क्योंकि मारी जो है वो खुद एक ट्रेडमार्क है. तो two different companies cannot sell the same name Mari product. तो क्या करते हैं companies? One will have Mari, somebody will have Vita Mari, somebody will have Mari Gold. Okay. अलग अलग उसमें नाम में एडिशन सब्ट्रैक्शन करके उसको नाम थोड़ा बदल देंगे ताकि उनको ट्रेडमार्क वायोलेशन ना हो. Okay, एक केस स्टडी लेते हैं. We'll look at a simple case study. This is a case study of a company called as My Dentist. Maybe you might have heard of it. So this My Dentist was a company which started to give this service. You know, ये आजकल के Uber, Ola के ज़माने में, what they tried to do was they tried to create centers or clinics, dental clinics, which were branded. अभी क्या होता है? You go to a dentist, you go to a particular dentist. You don't go to the dentist का clinic का कोई specific नाम होगा ऐसा जरूरी नहीं है. You may have Dr. Mehta's dental clinic. अब My Dentist ने क्या किया कि they said कि नहीं, we will create dental clinics with the brand name. Like we have Apollo Hospital, जो बहुत सारे Apollo hospitals हैं इंडिया में. वैसे उन्होंने बहुत सारी डेंटल क्लिनिक्स खोली, उनका नाम दिया माई डेंटिस्ट. बट ये 2 साल वो कंपनी थी और उन्होंने ना ट्रेडमार्क रजिस्टर नहीं किया था. जब वो रजिस्टर करने गए तब पता चला कि एक ही महीने पहले एक दूसरी कंपनी या रादर एक डेंटिस्ट है बैंगलोर में जिन्होंने ये माई डेंटिस्ट नाम ट्रेडमार्क करके रजिस्टर कर लिया था. So he was in Bangalore. Now this doctor had a single clinic and his clinic's name was My Dentist and he had registered the trademark. As a result, this My Dentist company, which had more than 200 clinics in India at that time, came into trouble because they wanted the name My Dentist, but उन्होंने register नहीं किया था. एंड यहाँ पे ऐसा हो गया कि ये 200 क्लिनिक होने के बावजूद trademark was already granted to another doctor. So they went to court, they tried to argue, they tried to give money to this dentist and take that name, but the dentist did not agree. The matter went to court, and the court said nothing doing. The person who registered the trademark first, it is his right, and therefore my dentist had to rebrand itself. And सारे के सारे स्टोर, उनके जो क्लिनिक्स थे, जितना भी उनका जो मटेरियल था, सब जगह से उनको माय डेंटिस्ट का नाम हटाना पड़ा और उनको नया नाम देना पड़ा. So my dentist became सबका dentist because my dentist was already a trademark registered by a doctor in Bangalore. So imagine the amount of cost this new company had to bear in rebranding itself completely from scratch. Imagine the customers जिनका क्या हुआ होगा कि जो कल तक माय डेंटिस्ट की क्लिनिक पे जा रहे थे, सडनली वो माय डेंटिस्ट वहां पे है ही नहीं, वहां पे कोई सबका डेंटिस्ट आ गया, अब वो ही है कि कोई और है मालूम नहीं. तो कितना प्रॉब्लम होता है. तो ट्रेडमार्क इज इन अ बिजनेस, इट इज अ वेरी इंपॉर्टेंट concept. So whenever you start with something, when you want to try something, when you want to build your application, you want to become a content creator and you want to create a name of a show or of any किसी भी चीज का जब आप नाम देते हैं, सिंबल देते हैं, टैगलाइन देते हैं, you have to make sure that you can trademark. In fact, one of the most unique trademarks is आपने कैडबरी का डेयरी मिल्क तो खाया ही होगा. कैडबरी कंपनी का बचपन में हम सब ने, आज भी खाते हैं, मोस्ट फेवरेट चॉकलेट ऑफ एवरीबॉडी. नाउ दिस डेयरी मिल्क के बहुत सारे ना काउंटरफिट डुप्लीकेट्स मार्केट में आने लगे थे. डेयरी मिल्क ने, कैडबरी की कंपनी है, कैडबरी कंपनी ने जाके उनका जो पैकेजिंग करने का जो वो वायलेट कलर का पैकेजिंग है ना, जिसमें डेयरी मिल्क बिकती है, उनका एक स्पेसिफिक कलर है ना डेयरी मिल्क का, वो कलर को ही ट्रेडमार्क करवा दिया कि कोई भी और चॉकलेट कैन नॉट सेल विद दैट सेम कलर रैपर. वेरी रेयर, but that combination of color of that violet with that gold which dairy milk uses was copyrighted, was trademark, was registered a trademark, and therefore today you do not find counterfeits of dairy milk easily in the market because it is a registered trademark. The color itself is a registered trademark. तो जो दूसरे चॉकलेट्स होते हैं उनको कलर, दूसरा पैकेट का कलर अलग रखना पड़ता है. They cannot give a similar color to them. So when we want to register a trademark, please remember that there is on the government website, I shall share the link also, you can actually search for trademarks. So whenever you want to register your trademark, you first start and search that there should be no other trademark with that same name or whatever tagline or whatever you want to register, उस पे already कोई trademark exist नहीं होना चाहिए. पहले वो सर्च करना चाहिए.